of the case.
Very briefly indeed.
Mr. Trent had suffered heart problems since he was born, for which he had undergone 3 previous operations. After being admitted to hospital for a problem at age 24, he suffered a cardiopulmonary arrest or waiting for an operation. He was not resuscitated because of a DNR order issued by his doctor and subsequently died. The applicant, Mr. Trent's parents, were granted permission to bring a judicial review to the High Court against the hospital based on the fact that the hospital was responsible for breaching Article 2 and 14 of his ECHR rights and that the DNR order was unlawful. My Lord, I will be making 2 key submissions to show that the defendant acted unlawfully and breached Mr. Trent's Article 2 rights. Firstly, it will be shown that the positive obligation to safeguard life established by Article 2 means that DNR policies must strictly comply with this right so as to not breach a positive duty. Secondly, I will go on to suggest that the hospital's resuscitation policy was not complied with due to the failure to consult Mr. Trent's parents, Mr. Trent himself, and a more senior practitioner. Firstly, I would like to address your Lordship on the issue of the positive obligation of the state to uphold the right to life and how this relates to DNR policies. This point begins at point 14 of my skeleton.
Thank you.
If your Lordship would kindly go to the 3rd tab, to the European Convention of Human Rights, at the top of the page 449.
Yes.
Article 2 explains that everyone's right to life shall be protected by law,
Yes.
and no one shall be deprived of his life intentionally. And if I could now take your Lordship to the 8th tab in the bundle, to the judgment of Osmond and the United Kingdom.
Yes.
Although the facts of the case are far removed from this case, would your Lordship benefit from a summary of these facts?
Not really, no. I think we just gave the principle that would be fine, actually.
If I could take your Lordship to page 153 of the judgment,
Thank you.
to paragraph 115, to the highlighted section, the court held that the court notes that the first sentence of Article 2 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the lives of those within its jurisdiction. Your Lordship may wish to note the case of Powell in the United Kingdom. The court affirmed at the bottom of page 203 the need for states to take appropriate steps to safeguard the lives of those within its jurisdiction. If I could now take your Lordship to the 5th tab of the claimant's bundle to the case of Calvelli and Siglio in Italy, which was to the European Court of Human Rights, at page 81 of the bundle,
Yes.
would your Lordship benefit from a brief reminder of these facts?
Will the facts help me, or do you think it will be sufficient to give a look at what they say?
I would rather talk about the principles, that's fine.
Sounds realistic to me, yeah.
Reading from midway down, paragraph 48,
Thank you.
it states that Article 2 says, enjoins the state not only to refrain from the intentional taking of life, but also to take appropriate steps to safeguard the lives of those within its jurisdiction, as I said. It then goes on to paragraph 49 to state that those principles apply to the public health sphere too. My Lord, it is submitted to the court that because of the strong positive obligations imposed on the state to safeguard the lives of their citizens, it therefore means that DNR orders should only be made in accordance with clear policies and only in certain defined circumstances.